Mr. Chair, members of the board, today we are presenting the ordinance amendments that we were directed by your board to develop on June 11th. It's the culmination of quite a bit of work that went into reviewing the ordinance and working with the Planning Commission and then coming before the board. I have Dan Klemann here, the Deputy Director of Long Range Planning, who will make the presentation, and I think it's rather short given the pretty clear direction that was given by the board.
Thank you, Ms. Plowman. Mr. Klemann.
Good afternoon, Chair Hart, members of the board. This is going to be a brief presentation, so very quickly I'm just going to do a recap of the direction we received from your board on June 11th and how we drafted the ordinance to achieve what you wanted to see in that direction. And then I'm just going to very quickly go over some of the main effects of these amendments and then finally the recommended actions if your board would like to adopt that ordinance today. So taking the first item, you can generally break up the board's direction on June 11th into, I'd say, 5 different areas. 2 have to do with permitting requirements, 2 have to do with development standards, and 1 has to do with the applicability of the ordinance, which I'll go over in just a minute. So taking the first item, the first change that your board directed us to make as part of these ordinance amendments is to prohibit commercial activities within existing developed rural neighborhoods, or EDRNs. The second change that your board directed us to make would only apply to the Ag 2 lot. And on Ag 2 lots, if a cultivation area is proposed which exceeds 51% of the subject lot area, the project would require a conditional use permit as compared to a land use permit as currently required. With regard to the 2 changes to the development standards that you requested, the first had to do with the setback requirement for cultivation areas, and more specifically, you requested us to draft ordinance amendments that would require cultivation areas to be set back a minimum of 50 feet from all legal lot lines. And then finally, you directed us to create a development standard that would require on-site drying and processing activities to be located within an enclosed building that utilizes best available control technologies for cannabis odors. I will be getting into a little bit more about this further on in the presentation, but we did provide an option for this, which I'll describe in a minute. Now, with regard to the applicability of the new regulations to our pending applications, pursuant to County Council's advice at the last hearing, we included their recommended language, and it effectively addresses the 3 types of stages that an application could be in if it has been approved. The first has to do with a project application that's been approved, but there's been no appeal of the approval decision. In that situation, the new regulations would not apply to the approved project. The second scenario would be a situation where an application was approved but and went through the appellate process. It was not subject to litigation, so there was a final decision as a result of the appeals. If a project application has reached that stage by the time the ordinance would take effect, the new regulations would not apply to those applications. And the third scenario of final approved permits to which the regulations would not apply would be those applications that are now subject of litigation, and the approval decision of the county is being challenged. So in those situations, if the county prevails and the approval decision is upheld, the regulations would not apply to the applications. However, if the county did not prevail and the approval decision is not upheld, the new regulations would then apply to the application if the applicant decided to pursue the project at that point. Now, I want to take just a minute just to describe the difference between an approved permit and an issued permit. I received a number of calls from members of the public over the weekend with regard to this. There's a bit of confusion about what an issued permit is, and this is more for the benefit of those who are listening in. Our approval process for land use entitlements generally takes a 2-step process. The first is approval. And cannabis land use entitlements, they're all approved with conditions. So what happens is when we approve the project, and assuming that the project approval is not appealed, then the applicant must go through the process of satisfying all those conditions of approval which must be satisfied prior to implementing the project. Once an applicant demonstrates that they have done so, then what we do is issue the permit. And at that point, the applicant may go ahead and implement the project. So if an application is already in the issued stage, that is well beyond the final approved permit stage. So all of those would not be subject to these new regulations. So we prepared ordinances to reflect these changes. They're included as attachments 2 and 3 to your board letter. They implement all of your direction and include the information about the applicability of the regulations to pending applications. So just a couple of main effects that we identified from these changes. First off, this is more for benefit of those who are watching in. All of the amendments that we're discussing today would only apply to the inland areas, so we're only amending the Land Use and Development Code, which governs that area. So we're not proposing any changes to the commercial cannabis regulations that apply to the coastal zone. With regard to the first change, the permit requirements, as the prohibition on activities within EDRNs, there's a little over about 25,000 acres of land that is located within EDRNs. And the EDRNs are diverse. They have a number of different types of zoning designations depending on where you're located. So this prohibition would not only affect cultivation on, for example, the agriculturally designated lots within EDRNs, for those areas where you have a small amount of commercial zoning and they're not subject to any other prohibitions on cannabis, they would also be prohibited by these amendments. And currently we have 12 applications for some combination of cultivation and accessory processing, which would be affected by this change. So with regard to the change to the permitting requirements for Ag 2 lots where greater than 51% of the lot area would be subject to cultivation, you have the option of using either gross or net lot area in that calculation. Net lot area is basically gross lot area minus all areas dedicated to public roadways. Sometimes there's confusion about where that line actually is and what areas are within the right-of-way. And so we've used gross lot area. It's administratively easier or more tidy to use, I'd say, as compared to net lot area. Also, we wanted to specify what is the actual physical area that constitutes the cultivation area. So for the purposes of this specific regulation, we provided language to clarify that it's effectively measuring to the perimeter of the planted area and excluding any ag roads. There are currently 11 project applications that involve cultivation on Ag 2 lots that exceed 51% of the lot area. And what we looked at was assuming that each one of these applicants wanted to reduce the cultivation area by the minimum required just to get their project approved with a land use permit as compared to a conditional use permit, it would result in a reduction of the proposed cultivation right now by at least 73 acres. So it gives you a sense of what sort of changes might result from this change in ordinance. With regard to the setback for cultivation areas from property lines, currently there are 48 applications that include cultivation within 50 feet of property lines. What I will say is that this number might be obsolete as of this morning because I've learned anecdotally from some of the case planners that some of the applicants have already started revising their applications in anticipation of the board's action today. So this number might be a little bit smaller at this point. Now, as I mentioned earlier, I wanted to spend a little bit of time on the accessory processing within an enclosed building because after your board gave us this direction, we heard from a number of representatives in the cannabis industry stating that they have different types of technologies and techniques that they're using to actually seal and package cannabis products in the field. And they're actually considering equipment that would be put on like a flatbed that would go around and assist with this activity. So what we included was just an option in the regulations which effectively says that outdoor processing would have to be in an enclosed building with best available control technology or some alternative technology or techniques which could achieve an equivalent or greater level of odor control that could be achieved if it is located in the building with the best available control technology. Just yesterday I spoke with Ms. Amy Steinfeld, who represents a number of the cannabis industry representatives. She informed me that in the draft language, we provide an example of technology that could be used. It's not a requirement. It's an e.g. or a such as. And I kind of muddled the description of the technology that they're using. So there was a little bit of concern about the effect of that language and what we were considering. So I just want to make it clear, first off, we were just trying to provide options for the operators, and if they could achieve odor control using the other types of techniques, we wanted to afford them that option. They don't have to use that specific technology that's used. And then finally, we had to make it clear what sort of processing activities are covered by these requirements, because as you might be aware, if you read the definition of cannabis cultivation in the glossary, it not only includes the growing of the plants themselves, it's very broad. It also includes trimming, harvesting, grading. So it includes a number of activities that are processing-like activities that could release a significant amount of odors depending on how it's conducted. So what we want to make it clear that what we're trying to get at is that extensive processing where you're trimming up the buds to make them into the neat, pretty flower that is then packaged and sold. It does not include the initial just cutting of the bud and dropping it into like a package to be taken off site. We want to make sure that we're all clear on that. We believe we achieved that in the language that we included in the ordinance amendments. I invited Ms. Steinfeld to provide some sort of alternative language if she had it. She didn't really have it at that point in time. And after I spoke with her about this, it seemed like we were all in line about what we were intending. It's just we want to make it explicitly clear what the effect of that regulation would be.
Just to add to Mr. Klemann's explanation is sometimes in the field, and I've seen this when I've been on a site visit, they will have sort of this mobile trailer that they have employees in that's shaded and whatnot, where they're actually trimming and working and doing processing in the field. And that's the kind of thing we don't want to see in the field, because that is what is odor generating. So the option that we've put into the ordinance is if you've got one of the freezing pieces of equipment in your field and you've got it out there, then maybe you take your cut buds and you could put it through the freezing and into bagging pretty quickly. That's an option. But we do not want to see the former happening. So I just wanted to make sure that was clear for the board and the members of the public.
Thanks. Yeah. And just one last point. There are 4 applications currently which include a proposal for outdoor drying and processing that would be affected by this change. So the recommended actions in order to adopt these ordinances are set forth in the board letter on pages 1 and 2. The actions are summarized here on the screen for the record, but they are generally that first you make the required findings for approval, including the CEQA findings, that you also find that the programmatic EIR that was prepared for the cannabis program is adequate for the environmental review of these changes, and no subsequent environmental review is required because this activity is within the scope of the project evaluated in that program EIR. Adopt the ordinance. It's 1 attachment, not 2. Sorry about the typo on the screen. And then finally, if you would like to provide direction to us to consider any other amendments, please provide that. So this concludes my presentation. I'd be more than happy to answer any other questions you may have.
Thank you, Mr. Klemann. Ms. Plowman?
Oh, just a point of clarification on the last item is that's county cannabis ordinances, so broadly inclusive and not necessarily just focused on Chapter 35.
Thank you. Any questions for staff?
I have one,
Yes,
Chair.
Supervisor Lavanino.
So, Dan, on the measurement of setback, I know in other places we're measuring from cultivation area. So I'm curious, let's say you've got a lot line, and then you have a road, and then you have a grow. Is the road considered part of the setback or not considered? How do you measure that?
Supervisor Lavanino, through the chair. Currently, it's written such that it's all measured in terms of setback from the property line. It doesn't take into consideration intervening features like a road or something like that.
The road being setback.
So the road,
Mr.
General?
Chair, yeah,
Okay,
Supervisor
go ahead.
Lavanino, the road is included in that buffer, so the road can count as part of the buffer. Yeah.
Okay. Good. One other question was, okay, so you brought up that that it's still, the language is, I read it a couple of times. I guess that's section 7O, what you were talking about with reducing the odor control during harvesting. When you reread that, is it in your opinion if it's clear without the sentence that's in parentheses, or how did you, at the end, does it get to where you wanted it to be? With the reference to freeze drying. So that I'm just trying to make it as clear as possible. What's allowed and what's not allowed.
Yeah, Supervisor Lavanino, through the chair. I'm not too concerned about it because, once again, it's listed as a EG or such as. That's one example of a number of different types of things that could satisfy that requirement. So I don't think it hurts nor hinders having it in there. So you could remove it if you want, but I don't think it's necessary. It doesn't have a material effect on how we would interpret and apply the regulation to an application.
Okay, thank you.
Any other questions for staff at this time?